All right, I think we have everyone here, so we'll go ahead and get things started. Good afternoon, everyone, and welcome to the final round of the James E. Bond Moot Court competition. My name is Blake Hoonan. I'm the chair of the Moot Court board. Before we begin, I just want to briefly remind those of us who are joining us live via Zoom, if you could please mute yourself unless and until you're speaking, and remain muted for the duration of the competition. Thank you. So arguments in this competition have been highly competitive, and we want to thank all the students who have come out to compete. We're pleased to announce our two finalists for the 2020 James E. Bond competition are Todd Brannon and Afton Gregson. Congratulations for making it this far, Todd and Afton. So we are fortunate to be able to host this competition virtually amidst numerous barriers and limitations this year has placed on our education and everyday lives. We could not have pulled this off without a huge amount of effort and support from Miss Lori Lamb. So Lori, on behalf of the Moot Court board, we want to thank you for once again helping us host this competition. We appreciate all you do for us. I also briefly do want to mention and thank our in-house competition chair, Caitlin Matthews, who you'll be hearing from in a few minutes. She has put countless hours into this competition. Thank you, Caitlin. Finally, I would like to recognize our faculty advisor, Professor Sly, as well as all of the practitioners and judges who have volunteered their time to judge the various rounds of this competition, spanning all the way back to late September. So thank you to everyone for your participation in this competition this year. So now I'm going to hand things off to Dean Clark, who will say a few words about Dean Bond and the Dorr family. Dean Clark.
Thanks so much, Blake. And I also want to recognize our Moot Court board and the work that you've done in bringing us to this day of our final round of the competition. It's an adventure to do this virtually. And so I hope everyone will understand. We expect it to be seamless, but if there are any glitches, please stay with us. We're excited to have you here with us today. This really is a signature event at Seattle University School of Law. In addition to recognizing the Moot Court board, Lori Lamb, who's already been mentioned, I want to acknowledge our students. This has been work that a lot of students have put in since September, working their way through the competition, leading us to the two finalists today. I also want to recognize our amazing legal writing faculty. We continue to have one of the top ranked legal writing programs in the country. I hear it from employers, from judges, all the time that our students and our graduates stand out because of the quality of their legal thinking, their legal writing, and their legal advocacy. And it really is a testament to our incredible legal writing program helmed by Janet Dixon and Mimi Samuel. So much gratitude and thanks to our faculty. I also want to recognize our four jurists today. They're going to be introduced by Justice Yu, Judge Keenan, Judge Schubert, and Judge Coburn. Thank you for being here today. It's such an amazing opportunity for our students, and we appreciate your service to our law school. Let me say just a few words about Dean James Bond, the individual after whom this competition is named, and we now run this program in his memory. Dean Bond passed away on September 16th, 2019. Fortunately, we were able to have a reception in his memory in February, shortly before we had to break for COVID-19. So we were able to gather in person to remember and reflect on the legacy of Dean James Bond. He was our dean from 1986 through 1993, and then again from 1995 through 2000. Very unusual to have a dean who serves twice, but he was that extraordinary an individual, and he is by a number of years the longest, or he was the longest serving dean of Seattle University School of Law. He was known for elevating the academic quality of the law school. One of the first things he did was to downsize the student body in order to improve the quality. He absolutely was dedicated to the legal writing program. As a matter of fact, early in his academic career, He was a legal writing professor, and so he understood the importance of good legal research, good legal analysis, writing, and oral advocacy. He was my dean. He became dean the year I joined the law school as a student. He also started me on my road to an administrative career, and I am indebted to him. I just wanted to read a quote that what he said when he retired in 2005. He said, "You cannot imagine what a joy it is to see one's students transform themselves into lawyers." Dean Bond was an extraordinarily good administrator and dean. He was an even better teacher, and he cared so much about his students. I'm proud to say that our Seattle University Law Review has just published a digital in memoriam section of our law review, in which a number of us wrote tributes to Dean Bond. I'm also very proud to say that we have an endowed scholarship in his name for students that is being funded initially by Georgiana Bond, his beloved wife, and we are seeking to add to that scholarship. And no surprise, it is for first generation students, something that was really important to Dean Bond. So as we listen to our oral advocacy today, and I know it will be of the highest quality, we do this in memory of Dean James Bond. Finally, I want to recognize and thank the Fred H. and Mary S. Dorr Charitable Foundation. And we have with us today Dr. Rick Dorr and his wife Pam Dorr as representatives of the Charitable Foundation. Since 2007, they have very generously supported this competition with scholarships for our winner and our first runner-up. This is a charitable foundation that is dedicated to making a difference in the lives of families affected by sudden infant death syndrome, enhancing the educational opportunities for students of achievement, and assisting the underserved in our communities. So much thanks to the Dorr Charitable Foundation and to Dr. Rick Dorr and Pam Dorr, who are here representing the foundation today. With that, I will stop talking and turn it over to Caitlin. Thank you again for being here.
Good evening, everybody. My name is Caitlin Matthews, and I am our in-house competition chair. I am going to introduce our final panel of judges tonight, starting with the Honorable Mary Yu, the Justice on the Washington Supreme Court. So Justice Mary Yu was appointed to the Washington State Supreme Court in 2014 after serving as a trial judge in the state's Court of General Jurisdiction for 14 years. The daughter of immigrants and the first in her family to go to college, Justice Yu was the first woman of color, first Asian and first Latina, and first member of the LGBTQ community to serve on the Washington State Supreme Court. Justice Yu is a distinguished jurist in residence at Seattle University School of Law and instructor of the Transition to Practice class since 2007. Next, the Honorable David S. Keenan. Judge David Keenan was elected to the Washington State Superior Court for King County in 2016. Judge Keenan currently serves on the Washington Supreme Court's Access to Justice Board and the Board of Choose 180, president of the Federal Bar Association for the Western District of Washington, and a member of the Seattle Community Police Commission. Judge Keenan also spent nearly 15 years in law enforcement, investigating crimes such as human trafficking and money laundering while attending law school at night at Seattle University School of Law. Next, we have the Honorable Ken Schubert. Judge Ken Schubert was elected to the King County Superior Court in 2012 and again in 2016. He currently serves in the criminal department. In 2018, he was the chief civil judge. Prior to becoming a judge, he worked in both civil and criminal law. After law school, he clerked for Justice Jerry Alexander, then began his career and became a partner at Garvey Schubert Bearer. Justice Schubert served on the Pretrial Reform Task Force and the Race and Criminal Justice Task Force. He served for 2 years on the executive board of the Latino Bar Association of Washington. He also served as a senior advocacy fellow for Seattle University's Korematsu Center for Law and Equity. And finally, we have the Honorable Linda Coburn. Judge Linda Coburn graduated from the Seattle University School of Law cum laude in 2005. She was a career public defender before becoming the judge in the Edmonds Municipal Court in 2015. She is currently on the ballot to join the Washington State Court of Appeals Division I in the upcoming election, which I believe we all already voted for. She is a member of the Washington State Supreme Court Minority and Justice Commission. Judge Coburn currently serves on an advisory committee to the Washington State Supreme Court for Gender and Justice Commission. So those are our judges for this evening. I do want to give a quick thank you to our semifinal round of panel judges: Jean Marie Claver, Office of General Counsel for the Washington State Bar, Dylan Doty of Dillon and Associates, and William F. Knowles of Cozen O'Connor. They were very helpful in our semifinal round, and we appreciate all that they had to offer. Go ahead, Blake.
Awesome. Thanks, Caitlin. And thank you again to our semifinal round judges and our final round judges for being here tonight with us. So next, to introduce the case you'll be hearing arguments for today, State v. Dawson. Please welcome Professor Sarah Rankin.
Hi, everybody. I hope you can hear me. Terribly excited to be here, so thank you for inviting me to give the introduction to the problem. The facts in this case began when police responded to a call concerning potential drug activity in a trailer habitated by Tyler Dawson and his roommate, Lindsay Sanchez. At one point, police entered the trailer and discovered Dawson, his roommate, and various items associated with methamphetamine production, both in the trailer and in a nearby pickup truck. Dawson was charged with the unlawful manufacturing of a controlled substance. Before trial, the court heard Dawson's motion to suppress an incriminating statement that he made to a detective at the scene. The trial court denied that motion to suppress and ruled that Dawson's statement was admissible. At trial, the jury heard about Dawson's statement and about the items found at the scene. Several months later, while Dawson's appeal was still pending, he filed a motion for relief from judgment on the basis of newly discovered evidence, a number of affidavits indicating that many of the items associated with methamphetamine production actually belonged to someone other than Dawson. The trial court denied that motion, finding the affidavits were insufficient. That issue was consolidated with the earlier appeal. Today, our incredible competitors will address two major issues. One, whether the trial court properly admitted Dawson's inculpatory statements to police, and two, whether the trial court erred when it denied Dawson's motion for relief from judgment based on the newly discovered evidence.
All rise. The Appellate Court of the State of Washington is now in session. Chief Justice Coburn presiding, joined by Justices Yu, Keenan, and Schubert.
All right, please be seated if you are standing. And we are here to hear the case of this State v. Dawson. Are the parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
I'm going to have the parties first introduce themselves.
Good afternoon, Your Honors. My name is Afton Gregson, and I represent Mr. Tyler Dawson.
Good afternoon, Your Honors, and may it please the court. My name is Todd Brannon, and I represent the state.
All right, well, welcome. All right, and Ms. Gregson, are you ready?
Yes, Your Honor, and may I reserve 2 minutes for rebuttal?
You may.
Thank you. The police had their tunnel vision sharply focused on Mr. Dawson before they ever met him that fateful day. Inadequate investigation combined with this tunnel vision to make Mr. Dawson an easy target in this case. a little too easy. Here, the court should decide first that the trial court committed reversible error when it denied Mr. Dawson's motion to suppress statements he made when he was coercively interrogated by Detective Davis, and that the trial court also erred in denying Mr. Dawson's motion for new trial based on new.
Counsel, can I ask, what's the standard of review in regard to our review of whether or not the trial court erred in admitting the statements?
Your Honor, appellate courts review the trial court's conclusions of law from a motion to suppress de novo. And the second issue essentially is that the trial court also erred in denying Mr. Dawson's motion for a new trial based on the new evidence that not only exonerates him, but evinces the true suspects here. So I'll first discuss.
Would be a different standard of review?
Yes, Your Honor. The new trial issue is reviewed for abuse of discretion.
All right, thank you, counsel.
Thank you. So I will first discuss the 3.5 motion to suppress, and then I'll move on to the 7.8 motion for new trial. A heavy burden rests on the state here to prove a knowing and intelligent and voluntary waiver existed. And the trial court erred in denying Mr. Dawson's motion here for 3 reasons. First, Detective Davis's conditional offer was tantamount to interrogation. He employed coercive tactics, and he did not scrupulously honor Mr. Dawson's right to silence.
But Ms. Gregson, can I just ask, when you talk about this offer, wasn't this just a routine booking statement? Wasn't the officer just telling these 2 individuals where they were going to be going next?
No, Your Honor, this was not a routine booking statement. The first clause of this statement, and I'll clarify the statement here, it is, quote, because nobody's taking responsibility for what was found, both of you are going to jail. And that's what Detective Davis told Mr. Dawson and Ms. Sanchez together. That first clause of that statement is not necessary to merely inform Mr. Dawson and Ms. Sanchez about booking here. The detective could have said, I'm arresting you for manufacture of methamphetamine. That would be informational. But because he used the term because, and this is kind of a contingent statement, that first clause is just simply not needed. And that this statement can
Counsel, would it make a difference, the fact that he brought the 2 co-defendants together and made that statement? What if they were separated and the officer said, hey, I'm going to book you on this, and told the other defendant the same? What if the officer made the exact same statement but made it privately to each one? Does that make a difference?
No, Your Honor. The statement in and of itself would be unconstitutional, whether it was made to Mr. Dawson alone or Mr. Dawson and Ms. Sanchez. The fact that he's using this contingent language, whether it's with both of them or not, is unconstitutional. However, the court notes a point here that the coercion aspect of this, that they're brought together, especially in light of Detective Davis's knowledge of their relationship, that they have an intimate relationship, that they're living together in the trailer, and the use of this contingent statement in that context makes this especially coercive. The court should evaluate coercion from the totality of the circumstances, from the defendant's subjective perspective. So here, it's not hard to imagine that Mr. Dawson, in this situation, when brought together with his girlfriend, when this contingent offer is made, it's not hard to understand that he felt compelled to speak up and protect his girlfriend.
Is there a case law you're relying on to support that under this type of circumstances, making a statement as the officer did is considered coercive or interrogation?
Yes, Your Honor. In State versus Johnson, there is a conditional offer is made, essentially that the defendant would not be prosecuted should the defendant decide to essentially give more information on the case and inculpate himself. And so here, this offer is tantamount to that detective's offer in State versus Johnson, especially because Detective Davis brought Mr. Dawson and Ms. Sanchez together as a psychological ploy. He was aware of their relationship and played to Mr. Dawson's affections for his girlfriend and banked on him taking the blame here. Additionally, Detective Davis did not scrupulously honor Mr. Dawson's right to silence in this case. It was Detective Davis that actually reinitiated this interrogatory type contact with Mr. Dawson without re-Mirandizing him. And similar to the—
Counsel, you're using the word interrogatory. What is it about the statement that makes it such? I mean, what does a reviewing court look to?
Yes, Your Honor. It's the fact that the statement is likely to elicit an incriminating response. And again, framed in this way, framed in the conditional statement, it is likely to elicit an incriminating response, especially in this context where Mr. Dawson and Ms. Sanchez are both standing there together. Mr. Dawson feels compelled to respond. So it is that likelihood that it will elicit an incriminating response that the court should consider.
And what other factors should we consider? Does the location matter, the timing? What other things ought a court consider?
Yes, Your Honor. In fact, in State versus Rubin kind of illuminates this point. Rubin was interrogated at a collision site and Mirandized there. And then he was subsequently brought to a hospital where he was also questioned, but not re-Mirandized. And in that case, he made some incriminating statements at the hospital, and the court held those statements to be inadmissible. That even though he was questioned at a separate place and brought to the hospital, he still needed to be re-Mirandized. And here you have Detective Davis being more violative than that you have the same officer, unlike Rubin, you have the same defendant, you have the same location and the same facts. It was Detective Davis who actually Mirandized Mr. Dawson and understood the invocation here.
So I want to make sure that we get a chance to address the second issue on appeal. But before we might move on, I just saw that you only have about 5 minutes left. Did you want to discuss the harmless standard issue that we might hear from the other side if we get that far?
Absolutely, Your Honor. So the court erred in admitting this statement, and that error was not harmless. Under the overwhelming untainted evidence test, the untainted evidence here is not sufficiently overwhelming to necessarily lead to finding Mr. Dawson guilty beyond a reasonable doubt. The tainted statement here provides that sole contextual link that the state relies on to link Mr. Dawson to the evidence found. The only other link to any of this evidence that's definitive involving Mr. Dawson is that single ring fingerprint on a mason jar in the bathroom of this small trailer. There was no final product actually found on the property, and the truck in which much of the necessary components for this method of manufacturing were found actually did not belong to Mr. Dawson. So in light of those facts, the admission of his statement was not harmless. So
Did evidence come in at trial that in fact those belongings in the truck did not belong to Mr. Dawson? Well, I mean, is that the evidence that came in at trial?
Your Honor, the evidence that was presented at trial was basically all of the components that were found both in the trailer and in the truck and in the surrounding vicinity of both.
Right. So at trial, there was no evidence that the items that belonged in the truck didn't belong to Mr. Dawson, correct?
Correct, but there was nothing actually that tied Mr. Dawson to any of those items. The truck had been on the property for a while. Mr. Dawson had been there a short time, only about 2 weeks. And then again, I'll kind of go over this more in my motion for new trial. But that truck and the evidence inside actually did not belong to Mr. Dawson.
So, are you asking us to simply ignore an important fact that you just expressed, and that is he was present, he was on the property for at least 2 weeks?
And he lived there.
That's correct, Your Honors. That's correct. And he did live there. However, this is a circumstantial case But circumstantial cases are significantly different than direct evidence cases because they do require the court to make some conjecture. They do require the court to make some inferences. And so here those inferences, simply, there are too many. So I'm going to now move to the motion for new trial.
And Ms. Gregson, can I ask you, since you're moving to that new issue, what I want to know about is why were these witnesses not available, at least in your view, when we're talking about diligence? So for example, Andrew Newberry was actually available at trial and was told by defense counsel that he didn't need to testify. So how is that new evidence when we're talking about diligence?
Yes, Your Honor. So that is new evidence, and essentially just merely his availability before trial doesn't actually preclude him from offering new evidence after the fact under State versus Slaniker. Just because the identity of these witnesses might be known prior to trial does not mean they can't offer new evidence after the fact. And again, here, even if he were subpoenaed to testify or brought in, he may invoke his right to silence under the Fifth Amendment. So there's no guarantee that he actually would have contributed at all beyond, what was put in these affidavits actually at trial. So these affidavits are very important and they are corroborative. The court should note that under State versus Wicker, hearsay statements are not significant generally. However, these are, if they're uncorroborated, I should clarify, but these are corroborated.
Counsel, would you concede that in fact, if the court rules against you regarding the first issue, the 3.5 issue, that those statements come in? If those statements come in, then regarding this newly discovered evidence, doesn't that make that less material?
No, Your Honor. It would be Mr. Dawson's position that it's not less material. It clarifies and it contextualizes again the evidence that was admitted at trial. So even if his statement,
but the statements that are coming in are not, none of those statements, I didn't read any of those statements as hearing in the briefing, that everybody said he was not involved in manufacturing. It just stated that the items in the truck belong to, what is it? Is it Newberry or Wallace? To Wallace, right? I mean, so if the statement comes in regarding your client saying what he said, if that comes in, then this court can surely find that the added information about, oh, well, those items in the truck belong to Wallace. I mean, we could say, well, that's not material because just because somebody else may have also been involved in manufacturing, it doesn't mean that the defendant was not involved. Correct? And I'll let you answer that. I see you're out of time, but go ahead and answer that question.
Thank you, Your Honor. So no, actually, even if his statement were admitted, this new evidence raises significant doubts about the ownership, essentially about Mr. Dawson's guilt via the ownership of these items, the very evidence that was used to convict him. He stated, you might find some of these various products, toluene, lithium batteries, but the rest of everything else was flushed down the toilet. Even with that statement, the new evidence calls into question the very evidence used to convict him to clarify that it does not all belong to him. And it reveals the true suspects here in the case. So again, the trial court erred in denying this motion for new trial. And I'll just quickly wrap up by saying to provide relief from this tunnel vision exercised by the state throughout this case, this court should reverse Mr. Dawson's conviction and remand for new trial. Thank you.
Thank you, counsel. Counsel Brannon, are you ready?
Yes, Your Honors. Good afternoon, and may it please the court. My name is Todd Brannon, and I represent the state. The court should deny the defendant's appeal for two reasons. First, the trial court properly denied the defendant's 3.5 motion to suppress custodial statements. And secondly, the trial court properly denied the defendant's 7.8 motion for relief from judgment. I'd like to pick up where counsel left off on the 7.8 motion. In State v. Williams, the Supreme Court of Washington provides that the appellate court extends extreme deference to the trial court's 7.8 ruling, reversing only for an abuse of discretion. Only two of the elements in Williams are in dispute today. First, whether the new testimony or evidence could not have been discovered before trial by the exercise of due diligence. And secondly, whether that evidence would have probably, not just possibly, changed the outcome of trial. In this case, Mr. Dawson has presented a number of affidavits as new evidence. In State v. Gassman, the court determined that witnesses cannot be deemed new if those witnesses or evidence were known to the defendant prior to trial.
But can I ask you, but can I just jump in, Mr. Brennan? I mean, at least with respect to Peter Wallace and Michael Cass, wouldn't they have just refused to testify anyway on the grounds that they might incriminate themselves?
Your Honor, insofar as the exercise of due diligence, the speculation that a potential witness may invoke the Fifth Amendment doesn't relieve the defense of the obligation to exercise that due diligence. And this is shown in State v. Hawkins, where a potential witness, the defense has to approach a potential witness and at least elicit and ask what they know and whether they would testify. Insofar as Mr. Wallace, he was never approached and he was never asked if he would testify. As to those,
I thought that the investigator did contact Wallace and Newberry and was told that they didn't want to get involved in this trial.
Your Honor, Mr. Newberry and Mr. Cass were contacted by the investigator. Mr. Wallace was not contacted based on the speculation that he would invoke the Fifth Amendment. However, that speculation doesn't relieve the defense of the obligation to, at the very least, approach him and ask about that testimony. As for Mr. Newberry, he was present the day of the arrest. He was present at trial, prepared to testify, and was sent home by the defense for reasons that are unknown. Again, Mr. Wallace was not solicited or asked for his testimony. And then lastly, Mr. Cass was there the day of the arrest. He owned the property. And in fact, he was the one who initially implicated Mr. Dawson in the manufacture of drugs in the first place. It came up from the investigator that Mr. Cass may have been unavailable as for fleeing the jurisdiction. But in fact, by the time the trial came around, he was already in jail. And on page 451 of the record, it reflects the defense requesting a jury instruction for a missing witness. The judge denied that on the basis that Mr. Cass was already in jail and that the defense failed to ask him, to find him in jail and to ask him for his testimony. As for the perception of that was brought up in Slaniker, certainly known witnesses can produce or present new evidence if they are unable to be located. But in this instance, Mr. Cass, Mr. Newberry, and Mr. Wallace were all known to the defendant and they were not missing or unavailable. Failing to, yes.
I'd like to just ask you before you get too far on this particular discussion in regard to Mr. Newberry. As you've indicated, the record seems to say that he was present at trial. He didn't testify. We don't know why defense counsel dismissed him. Let me just ask you, because this is very troubling to this court in terms of the relief afforded to a defendant, possibly because of ineffective assistance of counsel. Now, let me ask you, how do we view what happened at trial in regard to Mr. Newberry in this motion?
Your Honor, the amount of time that transpired between the arrest and the trial was over 4 months. Mr. Newberry was a friend and acquaintance of Mr. Dawson's. He was approached by the defense investigator, and there was ample time and opportunity to solicit that information. As to why, as you alluded to, as to why he was not, why he was turned away, it's unknown why he did that, but it appears that an equally plausible explanation would be that he was going to provide testimony that may not have been favorable to Mr. Dawson. And in fact, in his affidavit, he says that he was told to leave immediately before he was called by the prosecution, which implies there was a fear that he, in fact, was going to share incriminating information about Mr. Dawson. And so insofar as those—
I'm sorry to interrupt you, but I thought that he was told he wasn't necessary because they were so sure that the defendant was going to be found not guilty that they didn't need his testimony, not out of a concern that his testimony was actually going to be worse for the defense.
What he stated, Your Honor, was that the defense counsel sent him home immediately before he was going to testify, and that they wanted him to leave immediately before he was called by the prosecution. So again, as to why that occurred, why that tactical decision was made at trial is not exactly known. Yes, Your Honor.
Well, it sounds like you're going to move on to the other part, so I'll go ahead. So go ahead.
That turns us to the second issue, the second disputed Williams issue, which is whether this evidence would have changed the outcome of the trial. And this is determined by three qualities to evaluate new evidence from State versus Berry: the credibility, the significance, and the cogency of the evidence. As for credibility, none of these affiants have the requisite credibility. Mr. Cass, Mr. Wallace, and Mr. Newberry have all changed their stories from the day of the arrest until now. And the others, Mr. Cannelly, Ray, Calhoun, and Clearly, are all simply repeating statements that they learned from Mr. Cass in jail. The United States Supreme Court has addressed this particular issue.
Counsel, I mean, part of the newly discovered evidence includes somebody saying that material in the duffel bag, right, in the pickup truck was mine. It did not belong to the defendant Dawson. So would you concede that if this court decides that that statement that's at issue regarding question one of whether that statement comes in, if that statement doesn't come in, then this is extremely material on making a difference? Because then at this situation, then you're simply finding somebody who happens to be in a trailer with a bunch of items that are household items that could be in anybody's house. And the only link to that person and the items in the truck is because the truck happens to be located on the same property as the trailer, and that's it. So if somebody else is saying those items are mine, right? I mean, there was no evidence of an actual meth cooking lab at the property. It's just ingredients of creating meth. And he's charged with manufacturing, not of just possessing controlled substances here. So that link is crucial if his statements do not come in, correct?
No, Your Honor. So that speaks to the cogency of these affidavits, if that's what you're discussing. Each one of these affidavits only reference the items found in the truck, the ones that are claimed by Mr. Wallace. As for whether there was evidence of a meth manufacturing plant, there is overwhelming physical evidence from inside the trailer. That includes pseudoephedrine-soaked coffee filters, muriatic acid, lye, isopropyl alcohol, mason jars with white sludge that Frank Boshears, the forensic scientist, said appeared to be a byproduct of methamphetamine production, lithium batteries, lithium being a key component in the production of meth, a hand grinder, a pill grinder, plastic jugs with affixed funnels and hoses that the experts all said was indicative of a process called the Nazi method of methamphetamine production. Taken collectively, all of these affidavits address only one duffel bag inside of the truck that contained a number of items that were all duplicated inside of that trailer. There was significant and overwhelming amounts of evidence inside the trailer. All of those items have been claimed by Mr. Dawson at trial. Defense counsel in closing acknowledged that every single item inside of that trailer belonged to Mr. Dawson because his last trailer had in fact burned down a few weeks prior, and he moved all of his belongings and his trailer into that property. And with that, Your Honors, I'd like to move to the 3.5 issue. Detective Davis made a transactional and procedural arrest statement.
But Mr. Brennan, it wasn't transactional, right? I mean, what did the officer expect would happen when he talked about no one accepting responsibility? Wasn't that reasonably likely to elicit a response concerning responsibility?
No, Your Honor. He simply stated that the reason he didn't know who was responsible for all of the meth making items and apparatus in the trailer. And so therefore, both of them would be going to jail. Because is not a conditional or contingent statement. It's just a conjunction used to set up an explanation.
What's the need of him having to make that statement to them in front of each other? What is the purpose of doing that?
Simply notifying them why they're being arrested. They had been in custody for a few hours at the scene. And at that point, he was acknowledging or letting them know that the reason you are both under arrest is that these items were in your trailer, both of them. And both of them were subsequently co-defendants.
But he said more than that, that's the reason you're being arrested. He's saying because nobody's taking responsibility, I have to arrest both of you, correct?
His exact words were, because I don't know who's responsible for the items in the trailer, you are both under arrest for the manufacture of methamphetamine. And then they were arrested.
That's a different statement than you were being arrested for manufacture, right? It's saying because I don't know who's responsible. I mean, to me, that sounds like it does. Doesn't it reasonably, you would expect somebody's like, I don't want my friend or my girlfriend to be arrested, so I better take responsibility. Is that exactly what Ms. Gregson was arguing? Is that's what that statement like that would reasonably likely to elicit?
Your Honor, if those were the types of statements, as you just said, that had Detective Davis said things like those, then it could be argued that that would be coercive, but he didn't. It was a simple and brief statement. The decision to arrest had already been made, and bringing them together defeats the purpose of a prisoner's dilemma in the first place and wouldn't be coercive. And that the question or the evaluation of this statement is whether it scrupulously honors Mr. Dawson's rights, based on whether under the Rhode Island versus Innis standard, whether it qualifies as interrogation or subtle coercion. And the Innis court held—
Mr. Brannon, just to interrupt you, you said that it had been hours since the investigation started out there on the site. Where is that in the record? I don't see any. I just did a quick search for the word hours and time, and I saw nothing, but I obviously could have missed it. You're much more familiar with the record than I am.
A number of questions, Your Honor, when the responding deputies were on the scene, asked when they arrived, and then the time between about 7:15 to 10:30 when Detective Davis arrived on the scene and ultimately arrested them. So they had been Mirandized once and then Mirandized again. And
but don't we care about that time frame in terms of when were they Mirandized and then how much time passed before the officer came back and then reinitiated contact? Isn't that one of the things that we need to concentrate on? And what exact time frame is that? Do you know?
So Detective Davis immediately Mirandized upon talking to Mr. Dawson, and then his speaking to both of them lasted only a couple minutes. And on that point, Your Honor, if the court were to find that the 3.5 ruling was in error, that error would be harmless. And the court would then apply the overwhelming untainted evidence test from State versus Gouloy to determine if that remaining untainted evidence would be sufficient for a guilty verdict. And in this case, it would be. The overwhelming amount of physical evidence or evidence period used to convict Mr. Dawson is from inside of his trailer. And while the 3.5 and the 7.8 are different, all of that evidence is inside the trailer and not addressed by the 7.8 either. Again, pseudoephedrine soaked.
I'm going to interrupt you and I apologize for that, but I'd like to go back to the 3.5 matter if I could. And that's because this court is going to be establishing a rule in regard to these kinds of statements. So let me just ask you, why is it so difficult to just have a bright line rule that once somebody invokes the right not to speak, why would we allow statements to be made by an officer and find ourselves in this situation again? As a matter of policy.
Certainly, Your Honor, Miranda addresses cutting off interrogation, but it does not stop all communication. And from a policy perspective, this could have a chilling effect on the ability of police officers and law enforcement to communicate with the community. So the alternative would be police could potentially make arrests in silence, which does not seem to be a positive policy prescription as a result of this. Police may become afraid to speak for fear of being the cause that a conviction subsequently is overturned.
But isn't that what Justice Yu is suggesting? Maybe we should have a rule where they're afraid to speak other than what they're allowed to do, which means letting you know why you're arrested, giving your Miranda, but once the right to remain silent is invoked, then that's right. We're saying the officers no longer should speak unless, otherwise warranted, that is a good thing. Isn't that easier for the courts to enforce?
Potentially, Your Honor, but then it does lead to the issue of whether police would be entirely silent. The statement that Detective Davis made, and in the 3.5, both sides testified and said that there didn't appear to be any aggression. He was being friendly. He was simply notifying them. So if we remove because, it appears the defense is arguing that if we simply remove because, the statement is acceptable. Whether the court wants to or could set a precedent on that level of particular language, it seems difficult. And so, Your Honors, in closing, the administration of justice in this matter has been equitable. It has been fair, and at this point, it should be final. And for these reasons, the state respectfully asks this court to find that the trial court properly denied the defendant's 3.5 motion to suppress his custodial statements, that the trial court properly denied his motion for relief from judgment, and to deny his appeal. Thank you.
Thank you, counsel. And rebuttal from Ms. Grigson?
Thank you, Your Honors. I would like to make 2 quick points here. First, to clarify this statement that Detective Davis made, the conclusions of law on clerk's papers, page 21 and 22, number 6, the statement is clarified in there, quote, because he could not determine who was responsible for the items found in the trailer, he was arresting both for the manufacture of methamphetamine. So he used the term because. And it's interesting that the state actually, in introducing this issue, used the term transactional here. And it is a transactional statement in the sense that it invites a response. There's a transaction taking place, absolutely. And so that statement is reasonably likely to elicit a response and can be sharply contrasted with the statement in State versus Sadler, where police approached Mr. Sadler in the back of a police car and informed him that they would be seeking a search warrant for his residence. He responded with an incriminating statement that he thought his victim was 19 or something to that effect, and his statement was admissible. So there is a sharp contrast between what the officer said there and the conduct of the officer in Sadler versus Detective Davis's conditional statement here.
Counsel, even if we agreed with you, all right, and say you're right, this statement should not have been admitted. Regarding harmless error, opposing counsel Brandon listed off quite detailed the type of evidence that was in that trailer that suggests that the items in there were not just household items, that they had been manipulated to use to support the charge in manufacturing. So isn't the error harmless?
No, Your Honor, the error is not harmless. And in order to clarify that those items found, in order to charge Mr. Dawson here, there needs to be a reasonable doubt. Essentially, this is a probable cause in order to charge him, and in order to convict, the state needs to prove all elements of this beyond a reasonable doubt. And here it is circumstantial. And again, circumstantial evidence differs from direct evidence, just in the fact that there are inferences that have to be made. Merely living next.
Ms. Gregson, we instruct juries every day that they can rely on evidence, whether it's circumstantial or direct, not to treat one more important than the other.
Correct, Your Honor, and that's true. However, just merely living amongst these items does not definitively prove that Mr. Dawson was manufacturing methamphetamine here on this property. So in closing, to provide, again, relief from the tunnel vision improperly exercised by the state here, in this case, throughout this case, this court should reverse Mr. Dawson's conviction and remand for new trial. Thank you.
Thank you, counsel.
All rise. The court is now in recess.
All right, that was some very impressive advocacy we just saw by both of our finalists. I'd like to congratulate both Todd and Afton for your performances tonight. It was really impressive stuff. Congratulations to both of you. And so up next, while the judges are deliberating, please join me in welcoming Professor Christopher Rideout and Professor Deborah Ahrens, who will be presenting the 2020 Mark Reutlinger Scholarship for Excellence in Legal Writing.
Thank you, Blake. Welcome, everybody. This is, as Blake just said, the award presentation for the Mark Reutlinger Excellence in Writing Scholarship. This is an award that's presented for the best paper written in a non-legal writing course. And we make this award because we value good writing, not only in our legal writing courses, but in all of our courses. Let me say just a word about Mark Reutlinger, Professor Mark Reutlinger, who is now a professor emeritus. Professor Reutlinger taught at the law school for many years, and among other things, he valued good writing. and was an advisor and friend to the legal writing program. I might also add that Professor Rettlinger still values good writing, and in his retirement, he writes murder mysteries, most recently one titled Mrs. Kaplan and the Matzo Ball of Death. So be careful out there. Each year, faculty at the law school may nominate one of their best papers, a best paper written by one of their students, for the scholarship, and judges choose the best one. I'm going to let Professor Deborah Ahrens tell us who this year's winner is.
All right, well, many of you are probably familiar with this year's winner because, as I like to call it, in the before times, the very last thing that this law school ever did live was run a symposium that was chaired by the winner of this year's award for SJSJ. And that symposium was on criminal justice reform. And honestly, in a lifetime and career of symposium attendance and participation, really one of the best organized and thoughtful symposia I've ever had the pleasure to attend. So it should come as no surprise that the winner of this award is someone deeply committed to criminal justice issues, now serving as a public defender, Jacob Walsh, who was at the time the chair of the SJSJ symposium. And I very rarely get the opportunity to nominate students for this award at all because I teach big lecture classes. But I had the privilege of getting to nominally supervise Jacob as he wrote the paper for which he is receiving this award, which is A Crisis Plaguing Washington State, Mass Incarceration and Remedies to Solve It. And this paper is a deeply thoughtful paper, consistent with Jacob and everything about him. He had identified an issue that I think in the coming months after he wrote his paper and submitted it, has gained an incredible amount of national attention, which is the crisis of mass incarceration. He focused his attention on Washington in particular and went through and identified by both kind of descriptively explaining and then supporting with statistics why it is that Washington's numbers look like they do. And then what he went on to do was to break through the hopelessness, right? To break through this is a crisis, what do we do about it? And provide us with some solid policy proposals about how you might go about reducing mass incarceration in the state of Washington, offering specific changes to our sentencing policies, whether they be sentencing guidelines or sentencing enhancements, or alternatives to incarceration for people between the ages of 18 and 25, who almost certainly are going to age out of crime anyway. So it's a wonderfully written paper, a wonderfully argued paper, and also in an era where I think a lot of us are trying to figure out how do we actually fix these social problems that we've identified, also a prescriptive paper that gives us ideas for what we can do. And one of the quotes I just wanted to draw out of the paper and close out this by telling you about is, he says, without remembering that even if someone does something heinous, they're still human, still have people who love them and can change their ways and achieve redemption. We can never truly find justice in our criminal legal system. So I'm really pleased to have had the opportunity to announce Jacob's recipients of this award. I believe he's here, and Professor Rideout, I don't know if you have him say a few words or what at this point.
Sure, he may say a few words.
Hi, everyone. First, I'd just like to say thank you to Professor Rideout, and also thank you to Professor Ahrens for all the kind words. I'm very grateful to have won this award. Professor Ahrens helped me tremendously with this article. There was plenty of emails going back and forth, and so I really don't think I could have done it without her and her guidance. And I'm very humbled to have won this award. This certainly came as a surprise to me, and so I was, very ecstatic when I got the email. And thank you to the Rettlinger family and everyone who made this scholarship possible. It's really nice to see some familiar faces tonight. Congrats to both of the contestants for the appellate competition tonight. You both did amazing. And thank you to everyone else for being here.
Thank you, Jacob. We didn't warn you. You had to talk in order to get the scholarship. Did we? You
No,
did a great
that's
job.
quite all right.
I read the paper. You did a wonderful job. So congratulations to you.
Thank you.
Thank you to Professor Ahrens for submitting the paper. And I'd also like to thank Lori Lamb, who organizes this writing competition every year. So thank you, Lori. So I think we're done with the award presentation, and we're just going to wait for the judges to finish their deliberation.
Thank you, Professors Rideout and Ahrens, and congratulations to you, Jacob. As Professor Rideout mentioned, if you have a little bit of patience, we're just going to wait for the judges to finish their deliberations before we finish off here and present the award and announce the winner. Thank you.
All right, our judges are on their way back. So once they are all here, we are going to start with feedback, and then we will have Dean Clark announce our runner-up and our winner.
So are you wanting us to start feedback right now? Is that what you're waiting?
Yeah, go ahead.
Oh, okay. Okay. Sorry. All right. Who wants to jump in first? Judge Schubert?
Well, since you're the chief, you're welcome to tell me to go first. I mean, speaking on behalf of all of us, just initially, we were extremely impressed with both of you, as you would expect for finalists in a competition such as this. And now speaking more for myself, excellent command of the record. I was really impressed with Afton Gregson's unflappable demeanor. She got hit with a question from Justice Yu. Maybe within the first 30, 40 seconds, she was still just in her introduction, and without missing a beat, hit the standard 100% correctly on both of them, which is always a good sign. If you get the standard review wrong, that's problematic. And just that unflappable demeanor was consistent throughout. Mr. Brannon, with his command of the record, holy cow, I thought he was going to tell us exactly the diameter of the tubes that were into the bottles, and he knew everything that was inside that trailer, and that record certainly exceeded the record that we had as judges. So I was very much impressed. And then his command of the case law was also very good advocacy on both sides. Between the two, though, I would be a little bit more hesitant to play poker with Miss Gregson. She held her poker face just a titch more. And I say that, Mr. Brannon, with the most respect possible, because as you probably might have seen me, I have a horrible poker face. And so that often happens with the people that are unfortunate to have to appear in front of me. They often say, well, I can tell from Judge Schubert's expressions that maybe he's not buying this argument. I'll move on to my next one. And so it's an affliction that I suffer from, and you have it far less than I do. So that's to your credit. Just the one thing that you might work on just a titch, because you are going to be dealing with judges that don't know the record as well as you do, and may not have the same understanding of some of the things that you came into the room with. So, but excellent on both sides. And I know that we've got a lot of folks to get through tonight, so I'm not going to take up much more time, but just, it was very enjoyable. And you can tell that the life of an appellate judge is a good life, because it was really fun to sit here. So I'm happy to defer now, Chief, to whoever's going to go next.
Judge Keenan?
Sure. Well, it's a real honor to do this. Dean Bond was my first law professor. He was my criminal law professor in law school. So I could not have imagined when I took his class that someday I'd be judging the finals for the competition that's named in his honor. I thought both of you were just fantastic, and would be ready to advocate in my courtroom, or I think before Justice Yu or Judge Coburn any time. Ms. Gregson, you were really just so steady. And so, as Judge Schubert mentioned, you handled that question that was thrown at you by Justice Yu very early on. But then Judge Coburn came at you with a hypothetical, and you stuck to your guns on that hypothetical. You were not willing to concede anything. And then you pivoted right back to your argument and did a great job of contextualizing things, defining what it means, what is an interrogation, weaving in the case law in response to the question from Justice Yu. So I just thought you were so steady, and that really served you well during your argument. And then Mr. Brannon, similarly, I thought that you were quite steady, and you were, as Judge Schubert mentioned, had a great command of the record. I was very impressed with your precision when it came to the record. And one thing I really liked about you is you were so conversational, right? So it felt like we were having a conversation. You weren't talking at us, you were talking with us. You had an excellent command of the case law. And I think, like Ms. Gregson, did a good job when you were thrown a question of answering the question, but then not waiting, pivoting right back to your argument, staying on message. I thought you both did a fantastic job, and it's a real pleasure to hear both of you argue.
Thank you, Judge Keenan. I'm going to go next because I'm going to let our Justice Yu go last, even though I got saddled with being presiding for this one. So anyway, congratulations. I know how much work it takes to prepare for these competitions. And so I know that you've put aside all the other things you can do in your life to prepare for these, because you have to be prepared in order to answer questions, to think on your feet, to pivot like you did. And I hope you understand that despite that this is just a competition, your experience preparing for these competitions will really pay off when you are practicing. It is unbelievable how much more polished and prepared you are of understanding case law and analyzing it. Because I can tell you, because I did every almost appellate competition I did when I was in SU, and I can tell you, Justice Yu judged me many, many times on those and in practice rounds, and she was not easy. She was very hard, but I loved it, right? The hotter the panel, the better for me, because I knew it would make me a better attorney. And even though these are unusual circumstances that we're in Zoom, I mean, this is not normal how we do things, but the reality is it actually might be normal in real life practice, right? So, which means it's a whole different skill set of how you prepare when you're in the courtroom versus that you're on camera now and everybody is watching you differently. So versus up close and personal. And that's just something that you have the benefit of going through this and doing. There's attorneys out there who only know live argument and they're very uncomfortable appearing remotely. But the reality is this is not just fiction, right? There are some courts now where that is how you're going to have to make your argument, even at the appeal level. So it's a good practice to have. Both of you, I think, and we know the reality of mock is that the facts are the facts. The problem is the problem. Like, you can't change what you've been handed and what side you're arguing on. And that's just what it is. And you shouldn't be judged on the actual facts or the case, because that's not the purpose of these. It's how you handle what you've been dealt with, but more appropriately, how you handle the interaction with the bench. Are you going to be able to answer questions? Are you be able to guide us back to where you want to go and to get your points in? And you guys both did such a great job of that. You didn't really get shaken to where like, oh no, I didn't get to my second point and now they keep interrupting me. And you didn't. Neither one of you showed that at all. So that's fantastic. That's really good. So I want to congratulate you on that. I know that part of these skills, though, these things, is that you want to become better. And so I don't want to just give you all compliments and nothing on areas that you can improve on, because that's the whole point of these, is you want to improve on them, right? So regarding Ms. Gregson, I came back and pushed a little hard about the circumstantial and direct evidence, because I'm like, you do not want to go down that path and say that, because I'm not going to let you do that, right? Because to really understand what the difference that is when you're making that argument, and those terms on what that means. And that has nothing to do with the fact pattern of the case, but just general understanding of the law, right? And also, if you have case law that really supports you, you want to get to there quickly and saying this is like this, or even case law that's bad, but that you can distinguish. You can say, you know what? This is nothing like this case that held that. And this is why it's nothing like that case. Because then we know that your argument is coming based in law, right? It's actually coming from case law. All right. Mr. Brannon, as Judge Schubert indicated, wow, there was a lot of facts in there we were not aware of. And there were definitely a lot of facts that you highlighted that we were not aware of, which is great, because you responded, because you're like, what is she talking about that it's not material? Let me point out these detailed facts, which is really, really great. All right. But at the same point, you want to balance your enthusiasm and passion, right, of what you know, to present it in a way that, let me just educate the bench and the judge on something that I'm worried that they're going to make a decision on that's based on the wrong information, versus thinking that, any type of frustration or any impatience of like, I have to repeat this again. So you want to, it's a delicate balance, right? So you want to just be aware of that. But I think you guys were just so fantastic. And I indicated, well, I'm not going to say anything else. That's for just Dean Clark to do. So Justice Yu, it's all yours.
Thank you, Judge Coburn. And I don't want to be repetitive, at all. And I know that the night is going on and a bit longer here for each of you. And yet, to the two students here, I just got to say is you were absolutely superb. I have to start there. And I really did really want you to know this. You could be in front of our court right now because this seemed to me what I do every single day is we are on Zoom. We are hearing from counsel via Zoom, and we see ourselves doing this for the foreseeable future. There's a lot of efficiencies in it. We don't think that we're losing a whole lot by doing this. And so you're really ahead of the game right now because you're having the chance to practice, because this is the way it is in real life. So good for you. I just have to say this is I'm going to compliment both of you for the appropriate virtual backgrounds. I know, Ms. Gregson, you don't have a virtual background. Mr. Brandon, I don't know if you have a green wall. I'm not quite sure, but it's very appropriate. We have already had some very odd backgrounds of people at the Supreme Court, like somebody arguing from their bedroom where you see the bed. Really very unprofessional, much of a distraction to the court. And it has nothing to do with the substance of your argument, but the fact that each justice noticed it and found it distasteful, right? That's enough already that you don't want that. So very professional looking is very, very important in terms of your background when you're in the virtual world. And both of you were so cognizant of the fact that you are arguing. And so I just have to comment on that. It's very, very well done. In terms of the substance of the arguments, again, you knew the arguments, and here are general comments. Be careful about how you characterize the facts, because you never want to really minimize the other side in some way. So I would just say be very careful about how you characterize facts, because you always want to be accurate. You really don't want to put down what's going on in terms of the other side, the other person, or the bad cop, if you will. Just be careful. I would also say that it's very important to be very even-keeled. You're an excellent advocate when you are even at oral argument. I know we all care very much, but there were times that I felt that one of you was a little exasperated with our questions. Be very careful. You want to be deferential. We are very rude at the appellate court. We interrupt, we stop, we direct you into a different direction that you don't want to go in. But that's appellate argument. And so you need to be flexible with that, and you need to not take it personally when somebody interrupts. And again, you don't want to get frustrated with the fact that you can't go where you're going. Just very important in appellate argument. I don't want to say much more because I don't think it's really necessary. I'm happy to meet with each of you individually if you'd like, in terms of individual feedback. I just have to say it was very impressive. You both were so good. This is a fun little fact pattern because this is also real in our courts. These are the cases that we get. They're really important. It's a chance for us to make some law, good or bad. And you did a beautiful job. So thank you very, very much for being such great advocates tonight. It's all yours, Dean.
Okay, I think that brings it to me. And I'm sorry to keep our competitors waiting just a little bit longer, but I first of all want to thank our jurists. Two of them are alums of our law school, so Judge Keenan and Judge Coburn, welcome back. Thank you so much. Justice Yu is not our alum, but she is our distinguished practitioner in residence. Distinguished jurist in residence, so we claim her as well. And Judge Schubert, we love you. We just don't have a formal title for you at this point, but anytime you want to have one with us, you just need to let us know. What an active, what a hot bench. So thank you for your service to these students, to our program, and to our law school. I'm still going to keep you waiting just another second. I'd like to ask both Afton and Todd if you would please unmute yourselves, and can you tell us who your Legal Writing 2 professor is, please?
Sure. My Legal Writing 2 professor was Professor Oates.
Thank you. And Todd, how about you?
I had the wonderful Professor Dixon.
Professors Oates and Dixon. Well, as I started this evening when I was talking about Dean Bond, I read a quote, and I'm going to repeat that quote again from Dean James Bond on his retirement. You cannot imagine what a joy it is to see one's students transform themselves into lawyers. I can promise you that Professor Oates and Professor Dixon are beaming with pride, having listened to the quality of the advocacy that you two made today under stressful virtual circumstances. And as our jurist, particularly Justice Yu, said, you could do this tomorrow and stand yourselves up against very experienced appellate advocates. And I don't know if you've had a chance to see the chat, but people are saying it was amazing. It was the best we've seen. So congratulations to both of you. There are no losers here. You were both winners. You did a remarkable job, and we all are beaming with pride, and we will follow you as you graduate and your careers, and we know you both are going to do great things. With that, let me finally get to announcing the results, and I'm going to start with the runner-up. The runner-up is a recipient of a $2,000 scholarship from the Fred H. and Mary S. Dorr Foundation. And our runner-up this evening is Todd Brannon. Congratulations, Todd. And ordinarily, so you can see many people are clapping. Ordinarily, I would get the chance to shake your hand. You would be able to hear the resounding applause, but please know that that's happening. Each of us are applauding you in our own virtual world here. Congratulations. And by process of elimination, you've probably already figured out that that means our winner and a recipient of a $4,000 scholarship from the Fred H. and Mary S. Dorr Foundation is Afton Gregson. Congratulations, Afton. And so because we're not able to, take the photos with you and gather around you as we would in person, I really do encourage all of us to reach out to Afton and to Todd via email, however you can communicate. Let's do this on social media so that they have a sense of accomplishment in what they've done here today, and they know that we are, as I said, beaming with pride. One final thing I wanted to say before we close for this evening, we don't get to have our reception, is that I forgot to thank an additional person who helped make this happen, and that's Claudine Benmar, who's always working in the background to help us make sure that both the Zoom session goes well, but also we were streaming this live on YouTube. So we have a total of about 80 or 90 people who were in the audience for this program. Thank you everyone for joining us this evening. We did the memory of Dean James Bond, very proud. Thank you all, have a wonderful evening. And again, congratulations to Afton and Todd. Good night.